So in your sort of quest to find a hierarchy, or whether there is a hierarchy between precedent and practice and faithful agency, and you sort of talk about, Fallon thinks faithful agency is on top, and is it, I guess I wonder, so do you think it's true that the court sometimes goes against precedent and longstanding practice openly? It says this is the precedent, but we're going to overrule it. This is the longstanding practice, but we're going to invalidate the legislative veto anyway. But it never openly goes against the faithful agency model. It never openly says, here we're being unfaithful agents. Maybe they do it sometimes and lie about it. Maybe they don't always get the facts right. But is it right that they never contradict faithful agency in a way they do contradict the other ones? And if so, might that be a clue that faithful agency really is the strongest sort of or modality above them all?
So I don't agree with Hart on everything, but I do agree on a lot of things. So I was curious about your departure from that, and specifically the emphasis on the loser and what the loser accepts. And I was wondering if you could say more about why that's the appropriate focus, and to what extent this is an empirical or a conceptual claim that's the appropriate focus. In particular, I was confused by the claim on 15 and elsewhere that sort of decisional norms are legitimate when the parties comply without further compulsion, and that the means of enforcement are meager compared to the number of disputes. It seems to me that in the majority of cases, which if you include state cases are traffic and criminal court, that a lot of people comply because they think they will have people with guns put them in jail if they don't. And it's mediated through, as you say, the advice of their lawyers, that sort of other people in the system will take it as a norm of the system that you need to do this. But it seems to me quite wrong to say that the sort of nature of the legal system hinges on whether the tax protester defendant thinks that what's being done to them is legitimate. I mean, often they think that it's illegitimate, that the flag has fringes on it and belongs to an admiralty court, and therefore, this is all a fake proceeding and all that. It seems like the system is not threatened by that. And the reason it's not threatened is not because sort of other losers recognize the system as having sort of reasons for compliance, but because sort of they just recognize the positive fact that, like, this is the system, there are a lot of other lawyers, there are a lot of other policemen in it, and that sort of seems to be enough. So I guess why do you need to focus on the loser as opposed to the entire legal community at once? Hart draws a distinction between legitimacy, validity, and efficacy, and I'm not sure, but I think that this paper is really aiming mostly at efficacy. So it could be that there are legal norms that are valid, let's say the 15th Amendment ban on discrimination on the basis of race in voting, but not efficacious, as on the ground you would have a hard time exercising your right for a very long time after the enactment of the 15th Amendment. It seems to me that what you're talking about in terms of practice is really sort of what's going on the ground, not the question of what are the rules for the validity of a legal norm within the system, what are acceptable arguments to make, what things outrank other things, and so on. And so, Hart's emphasis is mostly on validity. Yours seems to be somewhat different, and I was hoping that you could sort of justify the departure.
I wanted to talk about the notions of the decisional norms being robust or qualified, and question whether that was maybe the right way of thinking about it. So it seems that the paper's about we have present-day legitimacy when there's sort of widespread agreement about what the decisional norms are, and people acquiesce to that. And it seems like those decisional norms that there can be widespread agreement about can exist on different levels of generality. And it may be that the first three that you call robust are high level of generality. And that while we may say moral norms are qualified, what we really mean is there are these few things over here, like you can't kill your father and benefit from it, where we have widespread agreement, and so that can form a norm that we all can agree with and find legitimate to follow, and other things where there isn't. And so that's not to say that it's not incorrect to say there's lots of different moral norms that can be used better and worse, but to say that what's really important is the degree of acceptance, and that can occur at different levels of generality, and the 5 categories kind of obscure that.
There's your
Okay.
3.
Thanks. These are great. I do think I share the intuition that the faithful agency type arguments are at the top of the hierarchy. I agree with Fallon on that point. Maybe the simple way to say that or to demonstrate that would be that, forget about the Constitution for a minute, if you're in the statutory realm and Congress overrides a judicial interpretation of a statute, the courts at least are supposed to then adhere to the new legislated norm. So everyone seems to accept that enacted law trumps interpretive decisions. I can't off the top of my head think of a situation in which the court has overruled an interpretation of the Constitution based on its conclusion that it's contrary to the Constitution. Maybe somebody else can help with that. It is true, Steve Calabresi's made this point, that when the court does overrule interpretations, it frequently does make reference to the original Constitution. Whether that's persuasive or not is another question. But I share the intuition that that there is this kind of vague hierarchy among these decisional norms, and that faithful agent norms dominate. But that's partly because I can sort of think of these faithful agent norms as being a little bit more particularized than maybe some people like the new originalists would think that they are. Steve, your point is well taken. I need to maybe grapple a little bit more with the with Hart's typology, and also, I don't teach jurisprudence. I'm not a kind of a player in this realm on a regular basis. And I think there is some interesting ambiguity in the paper that needs to be resolved between sort of a strictly Holmesian type of test that a decision is legitimate when the parties comply voluntarily, and the notion that the decision is legitimate when the party's attorney somehow advises that the decisional norms that were used are within the realm of acceptability within the legal system. So I'm not quite sure how I come out on that. I do think that people probably pay traffic tickets. If they're inclined not to pay the traffic tickets, then they consult a lawyer. The lawyer would say, well, eventually the state is going to, somehow try to collect this against you. If you get arrested with a warrant and it's found that you have 120 outstanding traffic tickets, you're going to have to pay them off before you get out of jail or something like that. And that might induce somebody to comply. And that is a very weak sense of legitimacy, although, so I need to give some further thought to exactly, usually you think of legitimacy as a kind of subjective acceptance as opposed to merely giving way in the face of superior force. So I need to refine the discussion there, and I haven't quite figured out how to do that. Christina, I think, there's something to what you say, but I don't think, I don't think it's entirely a matter of levels of generality. With respect to precedent, for example, if there's an on-point precedent that's very specific, I think that will tend to have a very powerful constraining force. So it's not just that precedent is a very general or abstract category. Within that category, there's much more specific and much more general or not quite on-point precedents. And the same you could say about faithful agent arguments. There may be very specific text that sort of dictates an outcome within that category. So maybe I should give qualified, not say that one is robust and the other is qualified, but simply be more precise about the fact that there are these different levels of generality within each of these categories. Or maybe that's a different dimension on which I need to discuss the problem. But thank you for that point. Yes.
All right, our next three are.
Sorry, please go ahead.
Steve, about losers, because this is a piece of the paper that resonates with me, and your emphasis upon the reaction of losers. When I was in the judge business, a lot of cases are decided, especially criminal appeals, with unpublished orders. And I can remember asking, well, how much, and they're usually 2 or 3 pages or whatever. And I can remember asking somebody, well, how much should be in one of these things? And the answer I got is just enough so that the defendant, because defendant is always a loser in these things, just enough so that the defendant will know that we heard and understood their argument and had a reason. They may not agree with the reason, but had a reason to reject it. And that really does strike me as important to legitimacy. The winners don't care.
All right, the next three, Randy Barnett, Stanley Fish, and Evan Burning. Randy.
Thanks. Tom, as I told you before, I really like the paper. I'm not a property law scholar, so your work in that area hasn't helped me very much in my work. And frankly, your previous con law efforts just have been so outside what I do and my project that it just has not been of any help to me. So it's quite good and quite provocative, but it's really never been anything that would influence what I might be doing. This paper is completely different. This paper, I agree with Mike, this paper should be read from beginning to end. It's extremely important. I agree with much of it for reasons I'm about to say. So I don't view this as outside my project. I view this like Jack's work. In fact, the two of you are really operating in the same territory here, which I suppose should give each of you pause. But it's all, you're operating in what we're calling the construction zone. Where outside what faithful agent interpretation will give you, and I have long thought that's a very important issue for originalists to deal with. And you have allowed in your approach for room for originalism. This is the part of the faithful agent, and then you've raised some important issues with respect to that. A faithful agency to a constitution that cannot be amended. It's a very important point. We all kind of know about it, and we think about it. Sometimes we talk about it, maybe not enough. So. How could your paper be, I think, a little more helpful? I think it might be a little more helpful, and Will's point gets a little bit at this as well, if it took more seriously the role of a written constitution in our constitutional order. You just sort of give it away a little bit in your comment. It's also pervasive through the paper. You do sort of accept that we have a common law constitution, like David Strauss says and like Eric says at times. You sort of accept, and I think Richard to some degree as well, and that the written constitution is sort of like kind of it's there, but it doesn't really play a role and maybe shouldn't play a role. No judge, as well as I do, no nominee could be confirmed as a judge who would express that view, if that's their view. Written constitution is there, it's optional, it's extraneous, doesn't really guide what we do. Nobody, in terms of our political culture, could not happen, would not happen, has not happened, won't happen, unless serious things change in our intellectual culture. All right, you need, as a positivist, you need to take account of that, and you don't, and you need to, or you're not actually capturing the reality you're attempting to describe as much as criticize. So what could the potential relationship then be between, but I agree, I concede the degree to which our practices don't have much directly to do with the written constitution. When I litigated the Raich case, I made no originalist textualist arguments. The entire litigation, I didn't do it. In the healthcare challenge, I made no originalist arguments. There were textualist arguments about the meaning and scope of commerce, but that just wasn't part of the game. And I made no apologies about that. But there was a relationship between what I was doing and the written constitution. And I think I've tried to make this argument out in my Fordham Law Review piece on the gravitational force of originalism. If you have a written constitution in the background, it's not a pure common law system anymore. If you have a written constitution in the background, and there's a culture in which that becomes an important part, you could call it sacred or whatever you want, it's an icon, whatever you want to call the written constitution, however you characterize it. If that's operating in your legal system, it will or should or can exert a gravitational force on, in this case, the practice of precedent, the selection of precedent, the interpretation of precedent, the rejection of precedent, because people in the background think that that textual constitution is something that we need to be faithful to. That's your faithful agent. And being faithful means we need to be faithful not just interpretation, but also with the precedent too. And that's faithfulness in the construction zone. That's what Evan and I have been trying to work on. What does faithfulness in the construction zone mean? And it is not unconnected to the written constitution. So I just think I'm very happy with this paper. I think it's great. I just think it could be better, and I think it could be better if it were a little more realistic about the full scope of our constitutional practices.
Well, I agree with Randy that Jack's paper and your paper, Tom, are in the same territory, although I might describe that territory a little differently. I welcome both of these papers as being anti-theoretical papers. That is, in Jack's case, he several times says that the topics that he describes and the workings of those topics, as he details them at certain points, will work independently of any theories that those who are embedded in the legal system might or might not have, which I took to mean that, in fact, what Jack's paper was doing was saying we don't need theory, and in fact saying we don't need my originalist theory either. All we need is to be inside the system where these topics are operating, where those to whom we speak also know and assume the centrality of them. And I take Tom's paper also to be non-theoretical, not only and untheoretical, not only in the sense that it forgoes any attempt to define interpretation or to give a master rule of interpretation, or even in any strong way to talk about interpretation at all. Like Jack, although in different accents, I think you're talking about the way things work. My only quarrel with the paper is with those few places in which you seem to be straining, or at least leaning in the direction of a theoretical or a normative perspective. So, for example, on page 19, you say, even if questions about the proper implementation of faithful agent argument is contested in academic circles, the central proposition that the adjudicator must act as the faithful agent of the enactor enjoys a very high degree of consensus in our legal culture. And then you go on to say, faithful agent arguments thus conform to the general criterion for legitimate decisional norms. Now, words like legitimate, general criterion go in one direction. That is, they go in the direction of thinking that there is some set of norms, more or less abstract, probably less abstract than more in your case, that can either be invoked or that are always in place. But I very much prefer the vocabulary of consensus and a phrase like in our legal culture, and your statements elsewhere that what you're dealing here is with a social practice. I would give that practice a kind of colloquial description by saying that what is really important in these matters is the kind of thing we do around here. The kind of thing we do around here, as opposed to the kinds of things that we don't do around here, which is, of course, the entire content of insider knowledge. That is the knowledge that this is a move in the game that we recognize, even if we would not, in fact, perform that move and don't like the way it's being performed at the present moment, but still it's the kind of thing we do around here. Or to pick up on Randy's vocabulary, it's part of the game. So when you say faithful agents must conform to blah, 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 I want to ask, faithful to what? And my answer is one I've already given. Faithful to the kind of thing we do around here. That is, faithful to the game that is being played, and we have committed ourselves to playing that game and utilizing its resources, and not utilizing or recognizing as legitimate others. And that is why it seems to me that you are worried about, what is the phrase you use, Scrabble board?
Yeah.
How does it go? Scrabble board what?
Precedentialism.
Yes, yeah. Because it's at those moments in my vocabulary, which is not at the moment yours, although I hope to persuade you, it's those moments in my vocabulary that you feel that someone is playing the game but straining its operation at the edges, so that when you say on page 45, when we increase it, what we increasingly see are decisions by the court that leave relevant precedents undisturbed, but add qualifications or exceptions that move the law in a direction favored by the policy preferences of the justices in the majorities, and so in other words, I would rephrase that to say at certain points, people who are within the game are performing moves that seem about to fall over the edge of it. And you think that there are more and more of those. I would respond by saying, if that happens enough times, those falling over the edge moments will become part of the game. So there's a kind of self-sustaining feature to the process, which I would, which I would associate, let's say, with a theory of autopoiesis like Nicholas Luhmann's, and that's why you don't have to worry, as you do not, about theory or worry about external forms of adjudication. And if you are worried about these moments, as you certainly are on page 45 and elsewhere, I wonder what you think the remedy for them is.
Following up on the Scrabble board theory of precedence, I thought I would try to pin down exactly what you believe the vice of it to be. Not to say that I personally endorse it, but let me frame a hypothetical. Say you have a justice who's convinced the Supreme Court has taken a terribly wrong turn in a particular area of law. The leading precedents, though, have tremendous reliance interests and a full-on assault on that area of law, say on a leading precedent like Humphrey's Executor or Rickard v. Pilburn, is just not going to happen. So that justice, in pursuit of what he understands not to be his policy preferences, but his duty as a faithful agent, delegated power under the Constitution to interpret and give effect to it in the best way that he can, decides to read favored precedents broadly, disfavored precedents narrowly, in the service of that constitutional vision. I think that there are a number of objections you could make to that, even as I framed it, but I'd like to hear what you think the vice of that particular practice would be.
Great. So, Randy, take the Constitution, the written Constitution, more seriously. Maybe not. I basically agree with David Strauss's description of how constitutional law operates in practice, which is that, the justices will dutifully cite the clause in the Constitution that's at issue, and then they will immediately say, "We have held," and then they give a description of all their holdings in this particular area. You know this, like Fourth Amendment cases and so forth, all proceed like this. So yes, the written Constitution is important as a kind of, kind of gesture or talismanic reference or something like that in these opinions. But whether it's actually doing any work is something that I'm not prepared to concede. I do mention in my paper briefly this astonishing decision, Whole Women's Health versus Hellerstedt from the term before last, an abortion case out of Texas. The clause of the Constitution that's being adjudicated is not mentioned in the opinion once. That's kind of like a breakthrough as far as I'm concerned. We don't even mention the clause of the Constitution that's...
Throwback.
Back to the Warren Court. Well, maybe. I think even there they kind of mentioned the clause of the Constitution that they thought they were interpreting or implementing or constructing or whatever the right word is. It's a deeper point, and I guess here Jack's work and my work kind of diverges. Jack has this, and I think building on your work, this normatively attractive notion of fidelity to the Constitution, that we have to maintain this connectedness to the Constitution and so forth. And I can see the attractiveness in and so forth. When I'm wearing my hat of the positivist descriptor of what's going on, I'm skeptical about whether that is actually having much to do with the way in which the constitutional law system works out. And as a normative matter, I then am concerned because I would like to see more of this kind of sense of faithfulness or faithful agency or whatever in operation, and the only thing I can think of is to say that maybe we should just try to downplay decision-making under the Constitution and make more decisions under statutes, administrative regulations, and state law where there actually is this give and take between the people and the interpreters. Stanley, I think your point is absolutely right, and it's a tricky one that I need to discuss in the paper, which is, and it's an uncomfortable one for me. So it's entirely conceivable to me that the game, as you put it, is evolving in ways that I don't like. I'm more than conceivable, it is in fact. And so I'm trying to give this positive description of what social practice is like, but it's entirely possible that social practice is evolving to the point that whatever 5 justices of the Supreme Court think is the Constitution, as long as they can get 5 votes, and as long as they don't have to overrule a precedent and they can pretend that they're still operating within this world of precedent, and they quote little snippets from this case and that case, and then they expand on certain precedents and contract on others, that will come to be accepted by the legal community, giving advice to the losers, as okay, that's legitimate. I grant that, and part of the problem with having this sort of positivist account is that it concedes that practice changes, and practice could change to the point where the Council of Revision that was rejected by the Constitutional Convention has in fact been reenacted de facto. And under my positive account, I guess I'd have to say, yeah, okay, that's where we're living now, you know. But my small d democratic instincts that Michael brought out caused me to be very unhappy with that. So again, I've got this tension between the positive and the normative aspect, but you're absolutely right to highlight the problem there. What's wrong with Scrabble board precedentialism? What's wrong with it, I think, is that, as I understand, Scalia threw this line out in his Tanner lectures because he was trying to debunk common law decision-making. He thought that it was a corrupt form of judicial practice compared to faithful agent or originalist interpretation of text and so forth. And his characterization of it was in which the common law judge or the Scrabble board precedentialist is just acting as the way the attitudinal political scientist suggests, just to maximize his own political preferences. And that strikes me as a path to disaster, if that's in fact what we've got going. And I've got a paper that I just recently gave on the regulatory takings cases, starting with Pennsylvania Coal and then up to the most recent Muir case, which says that, you know, the majority of these decisions are Scrabble board precedentialism. It's like, you know, if the conservatives win, the law tilts to the pro-property end, and if the liberals win, it tilts to the pro-government end. And they adopt these little, it looks exactly like a Scrabble board. You've got this baseline principle of Penn Central, then you've got this Loretto branch over here, and you've got the Lucas branch over here, and so on and so forth. And you know, I just think if that's what constitutional law has become, eventually, you know, we're not going to confirm anybody as a justice unless there's like some electoral wave election that allows that to happen. Your hypothetical of a conscientious faithful agent justice that wants to use Scrabble board precedentialism to move back to more of an originalist conception is entirely conceivable to me. But it's not what I see going on right now, which I regard as a sort of corruption of the judicial practice.
Michael, did you want to say anything on that?
I don't think so.
All right, our next 3 then, Richard Primus, John McHale, and Mike Rapport. Richard.
So, Tom, I like this paper a lot, as you know, by which I mean to say more than that I agree with it, though that's true too, for the most part. I want to engage the conversation about the degree to which you are and aren't offering a rapprochement with originalism here, and then maybe raise a caution about your self-description and preferences as a small d Democrat. And it goes something like this. You say, in the end, deep down, you know, I guess I'm an originalist at heart, because I'm a small d Democrat, and I would like to see decisions made that way and not with elite judges. And I don't like the idea of judicial policymaking and so forth. And I think those are all things that I say too, right? Or at least the aversion to judicial policymaking, the preference for policymaking through the other mechanisms of government. I'm on board with all those things. And I don't think they make me an originalist at heart. And I've rarely been accused of being an originalist at heart on the basis of the fact that those are my views. And I think that you may be, one possibility is you're using the idea of originalist at heart to mean I don't like judicial policymaking, right? And that would have made sense in the rubric of Bork's era of originalism, right? But it doesn't, I think, necessarily make you an originalist at heart. There are a lot of ways to be, it's not that the only alternative to judicial policymaking is originalism, right? It could be, in fact, that sometimes originalism is a thing that invites judicial policymaking. It seems like these things are orthogonal to each other, right? So then I think, so what does it mean, right, for you to say, I'm an originalist at heart? So like, it might reflect a sort of yearning for a very different sort of process in which we could have something like a constitutional system in which the processes of originalism were the ones that motivated and sustained that kind of democratic policymaking, either Keith Whittington style or Steve Sachs style or something like that. It's just that we don't have such a system, right? And then I wonder, is it sort of like saying, I'm a theocrat at heart, which means that I yearn for a system in which God would just tell us what to do, and it would always be benevolent and just and perfect and so forth. But in the absence of that system, right? So I'm not sure how much it tells us about your view of the system, right? And so it might just be you're suspicious of judicial policymaking, but that doesn't make any of this necessarily originalist. So I wonder why. And then the other thing, which is related, it's a caution about the idea that lacking formal amendments, there's an increasing disjuncture that's dangerous between policymaking and the people, or sometimes you say the great unwashed. And it goes like this. It's not that there isn't that disjuncture. I worry a little bit that the idea that more formal amendment would solve that problem is a little bit unrealistic. The process of Article 5 amendment, when it has occurred, or when it would occur, is also an elite process. Right? It involves. I'm running here a little bit along the track of what Tom mentioned yesterday about how like the great exertion of the demos to create the Constitution in the first place. It is a great exertion in terms of numbers relative to most other things. It's still a very small and elite slice of the population that's doing it. So it might be that that's not going to that if the reason to be an originalist is to hope for that, I'm not sure it's going to get you that either.
Thank you for the paper, which I also thought was full of good sense. I wanted to ask you about a distinction that I didn't think was drawn clearly in the paper, but I think has to be confronted, which is between explicit and implicit decisional norms, or to put it differently, the operative decisional norms, whatever they may be, and the overt forms or expressed forms of decision making. This is coming from the direction of cognitive psychology and cognitive science. All of this conversation about Hart and positivism and Holmes makes me a little bit nervous because it seems to me it's not taking into account some pretty well-established lessons of recent work in the study of psychology and decision-making, which in a nutshell includes the finding that much of what we do is opaque to us, that the operative reasons for our intuitions and our decisions is not necessarily what we express them to be. This is sometimes put as the distinction between operative and expressed principles, whether we're talking about language and the way we parse sentences, or when we're talking about the way we make moral judgments, whatever it might be. And it just seemed to me that at times you seem to be talking more about evidence that one would find in the judicial opinions, and that's how you were drawing your conclusions about the typology and maybe which hierarchy you thought was most descriptively adequate. And then other times you were talking about the actual operative sources of decision, or what are the operative rules or forms or norms of decision making. And I want to suggest that those can come apart. I mean, this is an old observation of the realists, of course, the judgment intuitive, or the idea that Holmes's idea that you decide the case first and determine the principle afterwards. It's pretty commonplace, but I didn't really see you grappling with that, and so I just wondered what you thought of that.
My question was very similar to Stephen Sax's about the claim that adjudicators need to do this so that their decisions are accepted. I'm not sure I took that to be in part a causation claim. That's why adjudicators do this. They're worried about this. I'm not sure that that's what the claim that you're making, but I guess I agree with Steve, first of all, that you can get people to do lots of stuff if you have force, the power of the state. And then I sort of wonder whether you have problems. You said, well, the adjudicators need the executive branch in order to enforce their judgments. But if they do need that, doesn't that then raise the whole question of how do adjudicators deal with the executive branch? Maybe the adjudicators need to be really careful, and maybe that's part of my view about what's going on in administrative law. There's too much deference to the executive branch, but I wonder whether or not this raises a whole set of issues here. So one way for you to deal with that is to spend some time in the paper dealing with those issues. The other possibility is I'm not sure you need it all for the paper. You might just have a conception of legitimacy that's out there without necessarily providing a causation claim. So anyway, those are some thoughts.
Okay. Richard. So I guess my claim to be a small d Democrat and an originalist at heart is really based on a sense that I would like to see policy making take place in a context in which there is some kind of give and take between, ordinary people and the interpreters or the enforcers of the law. And in this, I have an article coming out which talks at some length about the whole problem of unamendability and so forth. And my basic proposal there is to try to push decision-making down to a level where you have more give and take, rather than leaving it up in this rarefied sphere of constitutional decision-making, or interpreting statutes like 1983 or the antitrust laws or something that have not been amended for a long time. The Clean Air Act has not been amended since 1990, even though we now have all this concern about climate change. The National Labor Relations Act has not been amended in 75 years, even though we don't have any labor unions anymore. So these are like big problems. And what I guess I would like to see is, policy making, sort of subsidiarity, policy making sort of pushed down to a level where there is a little bit more of give and take, perhaps, rather than the opposite proposal, the sort of Bill Eskridge proposal that, the solution to this stickiness is to sort of have dynamic interpretation, and so the interpretive elite can sort of update things by using these broad clauses to update things in the way in which they think they ought to be interpreted. So my claim to be an originalist is really maybe an inapt way of saying that I would like policy making to be informed more by the subsidiarity kind of idea rather than by any type of originalism, the way most people in this room discuss originalism. Explicit and implicit norms. I take the point. I think my settled expectations or settled practice point, I think, really highlights this quite a bit. That nobody is going to hire a lawyer to claim that the use of paper currency violates the Constitution. Not because of any sort of black letter law that they've assimilated on this point, but simply out of a sense that would be a completely hopeless, quixotic exercise. But how do we learn that, or how do we obtain that sensibility is obviously, kind of a difficult sociological or psychological question. The real interesting issue that you raise, and again, I don't have any super strong views on this, is, to what extent are these norms that I talk about window dressing? That judges like Judge McConnell have to put into these unpublished opinions, but they don't really explain what's going on. And to what extent are these norms actually inputs into the decision themselves? And I don't think there is a clear answer to that question. I mean, you've got all these political scientists who say that, what is it, 30-some% of the outcomes of Supreme Court and Court of Appeals decisions are explained by the ideology of the judges. Well, that's, it's the glass half full, half empty problem again. It's sort of like, what about the other 70%? And there are other studies that suggest that legal norms actually do have a constraining force on judges. So I think it's a combination of things. I do think these norms actually do enter into the decision-making process in some significant way. They don't carry the ball all the way. There is this sort of the realists talked about the hunch, the judicial hunch, and so forth. And that's clearly going on here as well. But I think it's very important. The main point I would want to make is that the loser is going to accept this decision really only if advised by their lawyer that, in fact, there were valid reasons, decisional reasons given in support of this decision, and the judges were responsive to what they said. So I think that's, in that sense at least, I think these decisional norms are playing an important role. Causal claim, I'm not so sure whether this is a causal claim or not. It sort of relates to the same discussion we've just been having. Again, I need to be more precise, and I'll have to think this through after giving all your comments about, the extent to which I'm talking about the loser, the loser's lawyer, the enforcement agency's lawyers, the judge. I mean, these people are all existing in this community, and I do think it's a very salient and important fact that for the most part, the cops don't have to be called out to enforce these judgments. People comply voluntarily. Landlord-tenant law is a good example. People, their lease comes to an end, and most people vacate the apartment. They don't even wait for the sheriff to be called to come and throw their belongings onto the curb. It does happen, but it happens in a very small number of cases. And I think the judicial system is somewhat similar in that, people have a sense that there is the law, and if the law has been properly applied, that they have to comply with it. Our system would break down if we didn't have that particular sense. But it is a complicated, interactive process between people's understandings, unmediated by lawyers, mediated by lawyers, what they understand a court to have told them to do, what they anticipate the enforcement agents are going to do, and so forth. It is the basic point, I guess, would just simply be that if the courts start going crazy and enforcing some kind of bizarre notions that the lawyers and the enforcement agents just don't even recognize, stuff that Jack was talking about, Talmudic law and so forth, following, then the whole system would come crashing down. The enforcement agents wouldn't enforce the law. The lawyers would advise their parties that it's not going to be enforced. People would not obey the judgments and so forth. So there has to be some kind of commonality that sort of holds the glue that holds all this together. Whether that's a causal claim or not, I guess I'm not quite sure, but yeah.
So I'd like to comment on so Tom says he maybe in his heart of hearts is an originalist, and a couple things about that. It seems to me, Tom, you're not a new originalist.
No.
But you may be an old originalist, and the author of Burke versus Bork may actually be an Borkian, which I think may be a reviving position in originalist circles. I don't mean that as an epithet. In what sense is this you're an originalist who looks at the original Constitution and you like it, and what you like about it is how little it constrains our modern political practice, that it actually sets up a system that is quite small d democratic. Most things are not decided by the Constitution, and you like that, and that makes you an originalist. And here, I would love to hear you and Jack engage on this. I just taught the second chapter of Living Originalism to my seminar a couple of weeks ago, and my students were really struck by the opening metaphor of the book. And the opening metaphor, if you don't remember it, is skyscraper originalism versus foundational originalism. But they took it in an entirely different, they interpreted the metaphor in a more Tom Merrill-y way than skyscraper originalism, which Jack doesn't like, is skyscraper constitutionalism, is where the Constitution is said to, have principles that govern us and constrain us and decide our lives all the way to the sky. Tom Merrill originalism is actually foundational originalism, which is, no, all the Constitution does is it provides a foundation for political life. All of the construction zone, all of the skyscrapers should be left to democratic politics. And Jack thinks that the construction above the foundation should be constitutional politics, which is a very different kind of politics. It's a politics which centers on elites and courts and arguments rather than upon legislatures and referenda and votes.
I just want to say correct here. If you think this book is primarily about elites, you have misread the book.
All right, I think we are out of time.
I think we may have a disagreement about what elites are.
We may, but that's something we should take up another time.
We should take it out over lunch.
Take it outside.